Okay, delving into the world of intellectual property. Intellectual property encompasses really four areas: patents, copyrights, trademarks, and trade secrets. Together, intellectual property is like 40% of our gross domestic product, GDP. And so intellectual property is a huge area of law in the United States. Um, Mostly statutory in nature, some common law stuff, but we'll start with patents. And so patents are a legal right granted by the government to an inventor, giving them exclusive rights to make, sell, use, and distribute their invention for a limited period of time, typically of 20 years. The purpose of patents is to engage or encourage innovation by giving investors incentive of exclusive rights to their inventions, while eventually sharing the invention with the public. Three types of patents: utility, design, and plant patents. The utility patent protects new and useful inventions, discoveries of processes, machines, articles of manufacture, or composition of matter. Think of a utility patent as what it does. So the iOS operating system is a process or really a set of code. Design patent protects the way it looks or the way something looks. So new, original, and ornamental designs for articles of manufacture. The tiles in my Apple smartphone is a design feature. And then plant patents protect new and distinct, invented, or discovered asexually reproduced plants. So a new variety of fruit tree would be an example of a plant patent. So again, you can see the duration. The only one that's different is the design patent is 15 years and not 20. So what are the requirements for having something patented? Well, it's got to be not novel, non-obvious, there has to be a utility, and it has to be a patentable subject matter. So novelty, the invention has to be new and not known to the public before the patent application. So you can't patent something that's already been created. The invention has to involve an inventive step that is not obvious to someone with knowledge or experience in the subject. So improving an existing product that significantly advances the technology, not just a minor change. The invention has to be useful and be for some practical purpose. So a machine that performs a specific task. And it has to be a patentable subject matter. So it's got to be a patentable categories. You cannot patent a natural law, an abstract idea, mathematical formula. It's got to be a process, a machine, a manufacturer, or a composition of matter. To obtain a patent, this is a very simplified process because the patent application process is actually very long and expensive. But you do a patent search to make sure that the invention is novel and that there isn't already another patent out there. You have to draft and file a patent application with the USPTO. That patent application includes a description of the invention and how it works, specific aspects of the invention that the patent will protect, and visuals that depict the inventor's design or functionality. USPTO will then examine or review the application to ensure that it meets all the legal requirements. And then a lot of times they will ask for modifications or clarification before granting the patent, and then the patent is either approved or rejected. Moving on to trade secrets. A trade secret is any confidential business information that provides a company with a competitive advantage. This can include formulas, designs, processes, or any practical knowledge not known to the public. So they protect viable, valuable business information. So definitions of trade secrets or types of trade secrets. Formulas, secret recipes, the formula for Coke, or KFC's fried chicken. Processes, manufacturing methods, business processes that provide efficiency or cost savings. So a proprietary method for manufacturing microchips. Designs and techniques, unique designs or technical knowledge that give a product or service a competitive edge. So a algorithm, Google's algorithm, for example, which they change up about every 90 days. And so that algorithm is a trade secret that is expressly protected. Client and supplier information, customer lists, supplier lists, all of that is considered trade secrets. Marketing strategies, confidential strategies, or plans for promoting and selling a company's products or services. So your next big advertising campaign or a pricing strategy, all examples of trade secrets. The criteria for trade secret, first of all, it has to be secret. You have to keep the information genuinely secret, meaning that it is not generally known or easily accessible to the public. Coke's secret recipe is kept in a vault in Atlanta. The trade secret has to have some kind of economic value. It's got to provide a competitive or economic advantage to the business because it's not known by others. There have to be reasonable efforts undertaken to maintain secrecy, so you've got to take steps to keep it confidential, like the Coke in the vault. Also using non-disclosure agreements or security measures or restricting access to protect that sensitive information is required with a trade secret. How do companies protect trade secrets? Non-disclosure agreements, so contracts that employees, contractors, or business partners agree not to disclose. Restricted access, limiting access to trade secrets. Who has access to that information? Confidentiality policies, implementing company-wide policies that emphasize the importance of keeping trade secrets. Misappropriation of trade secrets would be the unauthorized acquisition, disclosure, or use of trade secrets. And trade secret owners can sue for damages if their secrets are misappropriated. There are both civil damages and criminal penalties. There was a case back in the 1980s, a secretary who had access to Coke's secret recipe went and tried to sell it to Pepsi. Pepsi, knowing that it was a trade secret, contacted Coke and actually engaged in a sting operation to expose this employee who ultimately later went to jail. She was with a boyfriend or something too at the time. They both went to jail, and Pepsi made sure not to view or took steps to ensure that they also protected Coke's original recipe, Coke's recipe, because they knew the importance of protecting the trade secret. And if they had used it, they would also be exposed to civil penalties, just as the employee was exposed to criminal penalties. Copyright is a legal protection to creators of original works of authorship, such as literature, music, art, or other intellectual creations. It gives the creator exclusive rights to use, distribute, and repurpose their work. The goal of copyright protection is to incentivize creativities by allowing creators to control their works while balancing public access to cultural and intellectual resources. So protected works, literary works, things you write, musical works, music that you create, dramatic works, plays, visual arts, film and audiovisual works. So when you walk into a play, the set design is copyrighted. Architectural works, building plans, choreography works, and digital works, all protected under copyright law. Copyrights typically last for the life of the author plus 20 years. So example, if an author dies in 2020, that copyright lasts until 2090. Works for hire, so works that are created as part of your employment or commissioned work, is 95 years from publication or 120 years from creation, whichever is shorter. And then once the copyright term expires, the work enters the public domain, meaning it can be used and reused by anyone without permission. So Shakespeare's plays at this point are in the public domain. Fair use, the fair use doctrine allows the limited use of copyrighted material without permission for specific purposes such as education, criticism, news reporting, research, and parody. In order for something to be considered fair use, there are considerations or factors that are taken into effect. Number one, whether it's being used for commercial purposes or for nonprofit educational purposes, whether the work is factual or creative, the amount of the work used compared to the whole. Generally, you can only use a specific, very small amount of a copyrighted work, and the impact on the market, whether the use affects the market value of the original work or not. Some examples of fair use, quoting a short passage from a book in a book review, using a clip from a movie in a classroom lesson, or creating a parody of a popular song. All examples of fair use. How you protect works via copyright? Well, first of all, copyright is automatic. As soon as you create a work, you receive copyright protection. When you write a paper, you are the copyright owner of your academic paper. It's protected by copyright law without the need for formal registration. However, you can register your work with the U.S. Copyright Office, which provides additional benefits, such as it puts the public on notice that you own that piece of copyrighted work, and it gives you the ability to sue for copyright infringement and seek statutory damages. In this age of content created stuff, we have the Digital Millennium Copyright Act, which is a U.S. law that was passed in 1998 to protect copyrighted material in the digital age. It addresses issues like online piracy, unauthorized sharing, and protection of digital works on the internet. If you create something and somebody uses your content that you've created, you can very easily download a Digital Millennium Copyright violation notice. You fill it out, you send it to them, and they have to stop using your works. And so the DCMA attempts to modernize copyright laws to address the challenges that are posed by the rise of digital technologies, including unauthorized downloading and distribution of digital content. Trademarks. Word, symbols, phrases, designs, or combination of any of those that distinguish the source of goods or services from one party to those of another. Trademarks protect brand identity, ensuring that consumers can easily recognize products or services and differentiate those products and services from their competitors. So, some examples. Word marks, a mark consisting of words, letters, or numbers. So, company name, Google, Coca-Cola, all examples of word marks. Design mark is a mark that includes a stylized logo or symbol, so the Nike swoosh, for example. Service marks, just like a trademark, but it identifies a service rather than products. So FedEx for Federal Express. Collective marks are marks used by a group or an organization to identify members or products or services that belong to the group. So CPAs are certified public accountants. That's a collective mark. And then trade dress refers to the overall look or packaging of a product. So the Coca-Cola design bottle, the shape of the Coca-Cola bottle, or the design of a restaurant's interior. All examples of trade dress. Uniform would be trade dress as well. Registering your trademark gives you exclusive rights. So the owner of a registered trademark has the exclusive right to use the mark in commerce for specific goods or services listed in the registration. Gives you legal protection against unauthorized use, also known as infringement. Gives you the right to sue and seek damages. Registered trademark helps to create a strong, recognizable brand identity, fostering customer loyalty and trust. Registration with the USPTO provides protection throughout the US, not just in a local area, and you get to use the little R with the circle symbol, which indicates that the mark is federally registered. Can you lose your trademark rights? Yes, if you stop using the mark, which we refer to as abandonment. If I open a restaurant and I have a specific, I have a specific design of my restaurant, and then I go out of business. Well, technically, I've abandoned that design, and it's free to use by anybody else that wants to open a restaurant and use that same design. And then generic use. There are products that their registered trademark has become so common that it is used generically in the marketplace. So Kleenex, for example, has lost the protection of the term Kleenex because a Kleenex is really a tissue, but everybody just calls it a Kleenex. Xerox, when you make a copy of something, it's also known as a Xerox. Xerox was the company that invented the Xerox machine, but now copies are referred to as Xeroxes, and so Xerox has lost that protection because of the generic use of the term. And that's what I have for you. Patents, copyrights, trademarks, trade secrets. All primary forms of intellectual property. Important to understand what they are, what they do, what they protect, and how to stay on the right side of intellectual property law.